Greetings, everyone. And if anyone's here, please get a little note in the chat. One, hello, hit the like. Want to wait till everyone arrives here. Is there anyone here yet? Could hit the song one more time until people show up. Just checking to see in the chat if anyone get the chat working here. Yep, looks like everything's functioning. All right. Anyone else? I'll wait for people to get here. I'll start the song again. How about a different song? All right. Waiting for people to get here. Leave a one in the chat or anything, or hello when you arrive. Okay, now I believe we have everyone here. All right, welcome everyone. Today we're going to go over jurisdiction from American jurisprudence, sources and determination of jurisdiction, and we'll also have Black's Law Dictionary handy to define any words we don't know or are unfamiliar with in this application, so we leave no word behind. With that said, let's get started. So we're going to be going, this is actually taken from American Jurisprudence, 2nd edition, courts. And we're looking specifically at jurisdiction, and we're going to start with in general. So generally, section 53. Although the term jurisdiction sometimes refers to the power of authority of agencies other than the courts, or to the power and authority of a state as a whole, the jurisdiction discussed here is the non-appellate jurisdiction of state courts in civil cases. Okay, so that's what we're focusing on here. State courts in civil cases. The concept of jurisdiction embraces a large number of ideas of similar character, some fundamental to the nature of any judicial system, some derived from the requirement of due process, some determined by the constitutional or statutory structure of a particular court, and some based upon mere procedural rules, originally devised for convenience and efficiency, and made by precedent made mandatory and jurisdictional. Jurisdiction has been defined as the power of a court to hear and determine a case or cause of action, or issue a decree. In its fundamental sense, jurisdiction refers to a court's power over persons and the subject matter, but also refers to the power to render the particular judgment sought, or, as it is sometimes said, jurisdiction of the particular case. Jurisdiction transcends all procedural considerations and involves the fundamental power and authority of the court itself. Okay, we got to pause for a second because we have this one isolated here as its own paragraph, and that's footnote 10. Let's look at that before we look at the cautionary. And that's Whippert versus the Blackfeet tribe of Blackfeet Indian Reservation in 1993 in Montana. Overruled on other grounds, though. So as far as this part applies, it was basically held. Once again, let's read this. Jurisdiction transcends. Hey, all right, we got people coming in. Well, this is for all of us, right? But yes, let's continue here. Jurisdiction transcends all procedural considerations. It transcends all considerations, procedural considerations. It involves the fundamental power and authority of the court itself. Caution: statutes merely addressing which court shall have jurisdiction to entertain a particular cause of action can fairly be said merely to regulate the secondary conduct of the litigation and not the underlying primary conduct of the parties. Such statutes affect only where a suit may be brought, not whether the suit may be brought at all. Okay, see, this is the beauty of American jurisprudence, where we take something it's hard to understand, but by the end of this, it sums it all up. We start with some good details and, basic principles, the details, and then it sums it up and boils it down to jurisdiction. It transcends all procedural considerations and involves these fundamental powers and authority of the court itself. And then we have this cautionary thing here that the statutes, right, only basically can state affect only where a suit may be brought, not whether the suit may be brought, which comes into back to the jurisdiction. So the statutes address which court, okay, and not the underlying primary conduct of the parties, which is your cause of action. Such statutes affect only, and this is key, where a suit may be brought, not whether the suit may be brought at all. Statutes. Okay? So look at statutes merely addressing which court. They do not gain standing in every sense. They only regulate where, the venue, I guess, in this case, the court will address the matter, but not the underlying matter of the conduct of the parties. And that being said, let me just remind everyone, this is not to be construed or thought of as illegal, lawful advice in any way, shape, or form, nor to be construed as advice to be done or used in your own purposes or practices in life. It's strictly for entertainment, educational purposes, and don't do this at home. Let's continue. So we have on the cumulative supplement some cases. Jurisdiction is a concept reserved for delineating the classes of cases or subject matter jurisdiction, and the persons or personal jurisdictions falling within a court's adjudicative authority. Let's break this down. So jurisdiction is a concept reserved for delineating, right? We're putting lines around the classes of cases. Classes of cases, we could say subject matter jurisdiction. Do you get it? What subject matter jurisdiction? It's the classes of cases, right? And the persons or personal jurisdiction, the persons falling within a court's adjudicative authority. Adjudicative is their legal authority, something that's worked in within laws or statutes or such, which gives them some type of legal basis of having authority. Okay? Whether it's lawful or not, it's adjudicative authority. So that's establishing jurisdiction. Classes of cases is subject matter, persons, personal jurisdiction that are falling within the court's adjudicative authority. Let's continue here. So as we have some basic stuff here for criminal law appellate review and these things here. Has a jurisdiction over the person and subject matter. See this. But we're not going to get into those tonight. We're going to focus strictly on this volume with courts and jurisdiction in particular, which is section 7 of the Courts of American Jurisprudence, 2nd edition. So, distinctions, venue, and jurisdiction. So let's make some distinctions here. Although venue has sometimes been treated as jurisdictional in nature, and the concepts of jurisdiction and venue have a close relation, the two concepts are distinct. Venue, in the technical meaning of the term, means the place where a case is to be tried or heard, while jurisdiction refers to the power of the court to adjudicate or hear and determine the merits of the case. That's number 4 footnote, and that's Slepika versus Illinois Department of Public Health, 2014. Wow, and Davis versus Wingate, Kentucky, 2014. So 2014, huh? Lots going on involving this. Number 4. Let's read this one more time here. That's 2014. It's rather recent. So this is whenever common law or something like that's changed in a current time period, I like to think about the context of why it was. Venue, in the technical meaning of the term, means the place where a case is to be tried or heard, while jurisdiction refers to the power of the court to adjudicate or hear and determine the merits of the case. Yeah, Brian O'Shea, we'll come on later and do a panel together, and then I'll show my face. Right now, it's just too much to keep the stream running while I go through this. All right. That being said, the merits of the case. Now, I want to just get into this a little bit here, what they're talking about the venue. And this is only since 2014 that they're looking at the technical meaning of the term. So, just a minute. Let me finish up this section here, and we'll start it up. I just want to finish on this thought here because I just want to bring in some insight here. That when we talk about the venue, right, in a technical meaning, and what I get this kind of to mean, we have to read into American jurisprudence. It doesn't give instructions like a cookbook. It gives the principles and the meaning behind the intent of the law. So this legal stuff is actually supposed to be focused on applying the law. And this is what we're talking about. So venue. Now when we start applying the technical meaning of the term, which I gather to be more the legal meaning, right? Means the place where a case is tried to be heard. While jurisdiction refers to the power of the court to adjudicate or hear and determine the merits of the case. Which is important because when you think about venue in a court of equity, is a court of equity a venue? I mean, technically it could be. But if they say it's not, because the technical meaning, because of this 2014 case, this could be an issue when you're trying to construct a case saying you're in a venue of a particular kind, and they won't give it that meaning. They want to try to pigeonhole it as a jurisdiction. How do we apply this? Not entering, this is what we're getting at. Understanding the foundations of this will allow us to construct our own approach to do this to stay out of the courtroom, which is what we're gathering at here. It has to start at this point. Once we get through this initial part of it, and that's kind of why we're already here at Section 54 of American Jurisprudence, this is something that we want to have down as a foundation. Another thing is this actually distinguishes us from a lot of esquires out there because they're not spending the time as we are right now on this panel, as few there as might be, to spend the time to understand the deeper meaning and the intent of the law so that when you're reading those dry codes and numbers and other things, it's not as lyrical. It doesn't read with the same kind of spirit that this does. And then, of course, it applies to all the actual case text that you could read, the narrative of the actual proceedings, the documents, and all of that. But that would be too much for tonight. So I'm just trying to give a general overview of the wisdom that we can gain from within American jurisprudence so that if we have to practice any of this stuff for our own purposes, that we can have a foundation, whether we're doing it ourselves or using others to assist us in counsel, to have such a strong foundation that we can understand the direction to go and have not just a chart, but a moral compass to be able to guide us through the litigious society we're in, whether we like it or not. So let's see. Let's continue on this section here, and I'm going to try and get some Brian O'Shea input on this and get him set up with a link. But that's going to take me just a moment. So I want to continue on this. Jurisdiction is the power to decide erroneously as well as correctly. Now that's intense. It's the power to decide erroneously as well as correctly. Stated otherwise, courts do not lose subject matter jurisdiction merely by interpreting the law erroneously. And that's case, or footnote 6, and that's Marriage of AmJur. What the heck? 1993 in Washington. Let's continue on this here. Is that the end of this section here? Let's see where we're at here. I want to try and get Brian O'Shea, but I want to be at a place we can break. Constitution and legislation as sources of jurisdiction. All right, I'm going to try and get him some links and set up, and then that way I can get him set up in the background while I continue on this. So it's just going to take me a moment to get that going there. But let me just read a little bit of this so that I can get something on the screen for everyone to read while I get that going too. But the courts may derive their jurisdictional power from the Constitution, from the legislature. Let's see here. Brian O'Shea, it was just to get your input on here about, let's talk about, you're saying how to stay out of a courtroom, right? And I'd like to just give some practical insight on how we could try to apply this to do just that. And if you want to give any, just points just as hypothetical, so to speak, that would work out great. It's not about critique or anything. It's about just doing a what a good anyone doing that stuff would do, a mock trial, a moot trial, something of that sort. Because if you don't have the experience doing it and you go into that arena, these guys do it every day. And I see how it works. It's not a pretty sight. The more you can do out of there, the better. And so, yeah, let's try to do that. Let's do this. Yeah, it's not that most are too lazy to read. What happens is that the esquires are tricked, and the people that go to law school are tricked that they don't have to do this. And that's the funny part, is because you pull this stuff, and you could really literally pull the rug out from under some of them. Now, there are ones out there that know this, but they're the big wigs. Those are the ones that are working with people. If you're lucky enough to be dealing with those people, you're probably already a high roller. For the rest of us, this stuff applies. Yeah, role playing there. I mean, this is a good mock to set up for that, to get our game straight for on his panel, because we don't have as large of an audience here to create the chaos that could happen or ensue. But it'd be a good exercise, I should say. Now let's get through this part here, because in the next section I think is a good break point. Let's see here. The next section is going to be foreign countries. Exactly. Perfect break point. So let's get this section done here, and then we're going to get Brian O'Shea up, and we're going to talk about doing some mock applications and see if we can start to get through the next sections after that. That might help us get a better insight on how we could approach this. It's really about an approach. No, but I mean, I guess, we could do with practical experience. I don't know how many you've been, but I've been through my rodeos, if you know what, so to speak. So I could give you a pretty good insight on how they behave, how they railroad you, how they act honorably. I've had the whole gamut, going back to my youth, actually. And I've had some actual very cool, honorable judges way back then, but they've passed away since then. But those kind of guys were a rare breed. I don't think they exist any further. But that being said, let me finish this section here. Let me get you to going on that, Brian O'Shea. Let me just give you the link again real quick. Did you get the link before? Brian O'Shea, did you get the link before? Yeah, there's an old saying back in law school that the A students, when they graduate, the A students end up working for the B students, and the C students become judges. All right, everyone. I want to thank you all for attending. I don't know how many people are still here, but I want to appreciate you all for sticking along. This has been a great stream. I really appreciate Brian showing up, and it's been a great learning experience for me too. And this jurisdiction is going to be continued next time. We're going to be going over some of the foreign aspects of this too. Because jurisdiction can apply in foreign courts as well as our local courts, depending on what the situation is. So, again, I want to thank everyone for coming, and I'll see you all in the next one. Peace out.